Hello everyone. So in this video we are going to discuss chapter called Governor, and with this starting Governor we are entering into part 6 of Indian Constitution. So if you remember, we already have dealt with part 1, part 2, part 3, part 4, part 5 of Indian Constitution. So let us recall it. So part 1 deals with Union and Territory spanning from article 1 to 4. Then part 2 of Indian Constitution deals with citizenship starting article 5 to article 11. Then part 3 of Indian Constitution, fundamental rights, article 12 to article 35. Then part 4 of Indian Constitution, DPSP, article 36 to article 51. Then 4A deals with fundamental duties, one sub article that is dedicated to this chapter, that is part that is 51A. Then part 5, the Union, the longest part of Indian Constitution, that spans from article 52 to article 151. Now we are entering into this part 6 of Indian Constitution that deals with the states, right, spanning from article 152 to article 237. So this has been the structure of Indian Constitution. So there are 22 parts of Indian Constitution, and out of these 22 parts we have already reached part 6 of Indian Constitution. And let me tell you that these two parts are the lengthiest part of Indian Constitution. Thereafter we had to have few articles dedicated with another part, so we'll complete that as well, right? So let us see that what is the scope of this video. So this is going to be the scope of this video. So first we'll discuss what is this rule of 89. So this is nothing but a memorization technique to remember important article, right? Then structure of states we'll discuss. Then what is the origin, the historical underpinnings of the origin of governor's office, then why this governor office came into existence, right? Why we have in colonial times, if you remember, this governor office was notorious for destabilizing the elected government. So if this office had become so notorious that it was destabilizing the elected government, why did we continue this office even after operationalization of constitution? Then what is the eligibility criteria if a candidate wants to become a governor? Then what is the qualification, what does oath he takes for the office of governor? Then problem with the appointment and its repercussion, and then finally MCQ. So this is going to be the structure of this particular video. In the upcoming video we'll discuss the powers of the governor, what is the executive power, what is the judicial power, what is the legislative power. So all these things we'll discuss in the next video. So I hope you would have understood the scope of this video. Let us move to the next slide and let us start discussing the structure. First we'll discuss the structure of this part 6 of Indian Constitution, that how many chapters this part 6 of Indian Constitution has been divided into, and thereafter we'll start discussing the core of this chapter, that is governor. So part 6 of Indian Constitution, as you can see on the screen, has been divided further into 6 chapters. So similar was the structure of union government as well. When we were discussing the chapter of the president, you would have noticed the same kind of slide there as well. So part 5 of Indian Constitution similarly had been divided into this 6 chapters. So here as well the states that has been mentioned in the part 6 of Indian Constitution has been divided into these 6 chapters. If you notice, the first chapter where one article has been dedicated. So the first chapter deals with the general information regarding the state, and you have one article, that is very first article of this part, that is 152, is dedicated to this first chapter that deals with the general information. Then the second chapter deals with the executive. If you see, the executive at the state level, governor, then council of minister including chief minister, and then advocate general goes on to become part of the executive. So here one prelim question can be solved from here itself, or one prelim question can be framed from here itself, and in the past such prelim question has been framed, right? So similarly, if you remember, at the union level this executive had been divided into president, right? So here in the place of governor you had president, then council of minister including PM, and instead of advocate general you had this attorney general of India, right? So if a question is framed that who are the people or which constitutional functionary makes up the part of executive at the state level, your answer would be governor, then council of minister including the chief minister, and then advocate general. So that is the second chapter. If you see, the third chapter has been dedicated to the state legislature. What is the state legislature? So it is nothing but a legislative assembly legislative assembly, and wherever applicable, legislative council as well, right, the upper house. So you do have 6 states where you do have upper house, otherwise wherever this upper house is absent, right, state legislature would mean only legislative assembly, right. So corresponding structure in at the union government, you had this Lok Sabha and Rajya Sabha. I hope chapter 3 also you would have understood what is this fourth chapter. So fourth chapter is dedicated to the ordinance making power of the governor. Similarly, at the union level, you had this ordinance making power of the president, and you had this article 123 that was dedicated to the ordinance making power of the president. Then fifth chapter deals with the high court. Similarly, you had at the central level union judiciary that was dealing with Supreme Court. Then the sixth chapter is dedicated to the subordinate court, and the sixth chapter there was dedicated to the CAG, right, article 148 to article 151, right. So you need not to remember each and every article that I continuously keep referring to. What you can do is that with the end of every chapter, be it governor, be it council of minister, be it chief minister, at the end of every chapter what I'll do is that I'll append list of a very important article, and you can just remember those articles, right, and you can manage by remembering only these articles. So I hope this part 6 of Indian Constitution would be clear to you. Now we are moving to the next slide to discuss what is this rule of 89. Let us understand this, what is this rule of 89. So this rule of 89 is nothing but article memorization technique. So if you know, we are following parliamentary system at the union level as well, and the same parliamentary system we are following at the state level as well, right. So equivalent of president at the union level, we do have governor at the state level. Similarly, equivalent of prime minister, we do have chief minister at the state level. Equivalent of advocate general, we do have, equivalent of attorney general of India, we do have advocate general. Similarly, the ordinance making power, if has been provided to the president, same ordinance making power has been provided to the governor at the state level. Equivalent to the union judiciary, that is Supreme Court, we do have high court and subordinate court at the state level. So whatever structures that we do have, or whatever constitutional functionaries that we do have at the union level, same level of constitutional functionaries we do have present at the state level as well, right. So if you would have remembered the important articles related to these constitutional functionaries or the structures at the union government, you would be easily be able to remember the article, corresponding article at the state level by following this rule of 89. And mind you, this rule of 89 you cannot apply universally to all the articles, right. So you can apply this rule of 89 to this area, but this rule of 89 won't be applicable in this area and in this area. Let us see the example, right. So if you remember, the pardoning power of the president has been discussed in article 72, we had discussed, right. So similarly, pardoning power has been given to the governor as well at the state level, right. So the corresponding article at the state level that is dealing with the pardoning power or the clemency power, if I say, at the state level to the governor, and that has been dealt in article 161. So what is the difference? So the difference is our 89 articles. If I discussed this prime minister and president relationship, so that has been discussed in article 74, that says that there should always be council of minister to aid and advise president, right. So article 74 has been that discusses the relationship of prime minister and the president. Corresponding article that deals with the governor and chief minister's relationship at the state level, the corresponding article is 163, again a difference of 89. If I talk about the appointment of council of minister at the central level, that has been discussed in article 75, right. Corresponding article that deals with the appointment of council of minister at the state level, right. So that is 164, again difference of 89. If I talk about attorney general of India, so one article that is dedicated to the attorney general of India, that is article 76. The corresponding structure at the state level to the Attorney General of India is this Advocate General, and that has been discussed in article 165, again the difference of 89 article. the assent to the bill. What happens when a bill passed by Lok Sabha and Rajya Sabha is sent to the president, that has been dealt. So what are the options that president has, right? That has been dealt in Article 111. Similar power of the governor, what happens when assembly passes or assembly plus legislative council passes a bill and it is presented to the governor. So that option has been given in Article 200. Similar difference of Article 89, right? So if you could remember, if you have been able to remember these articles starting from Article 72 to Article 111, right, or very important Article 72, Article 74, right? If you have been able to remember these articles, I can guarantee you that by following this rule of 89, you would be able to remember these articles as well. And if you cannot remember these articles, you just remember the articles at the union level and the function what those articles are dealing with. So you can simply add. So suppose if you do not know that CM governor relationship has been discussed in which article, and if you know at the union level this PM and president relationship has been discussed in 74, you can easily just add up Article 89 and you can reach to the corresponding article. So that was my point. But I am again warning that this rule of 89 is not universally applicable. So if you see the example, ordinance making power of the president that has been dealt in Article 123, corresponding power of the governor has been dealt in Article 213. So here the difference is not 89 but the difference is 90. If you see at the union judiciary level, starting article at the union judiciary level that deals with the Supreme Court, that says that there shall be a Supreme Court of India, that has been dealt in Article 124, and the corresponding article at the state level that deals with High Court has been discussed in Article 214. So that there the difference is Article 19. If you see the starting article, so the first article of Part 5 of Indian Constitution is Article 52, that says that there shall be president, and if you see the corresponding article at the state level that says that there shall be a governor of each state, so that is Article 153, the corresponding. So here the difference is of Article 101. So that was my point, right, that the rule of 89 is not applicable across this union and the state level, right, that is limited only from Article 72 to Article 111, right? And most of the important article that may be possibly asked in the prelims, right, that is limited only to these articles. And that's why I said that this rule of 89, if you could remember, right, and if you have been able to manage to remember the important, very important article at the union level, I can guarantee you that you can remember the articles at the state level as well. So this is rule of 89. Now we are entering, if you would have understood this rule of 89, now we are entering into the next slide to discuss the core of this chapter. And so to understand the origin of office of governor, we'll have to get into the history. So if you remember, we had something called Indian Councils Act, and there were three Indian Council Act. One was in 1861, then another was in 1892, and the third and the last Indian Council Act we had in 1909. And through these three Indian Council Act, nationalist forces or the reformist forces, reformist Indian forces asked for something called legislative reforms, right, and executive reform, which to some extent we got as well from British government. This on the legislative front and the executive front, we got some reform. Of course, not to the extent that these nationalist forces were demanding, but to some degree we got this reform. After 1909, we changed our gear and we started demanding something called state autonomy, that states or the provinces in the Indian scheme should get this state autonomy as well. And when we started demanding, we had various kind of protest movement ongoing with this demand state autonomy, and this demand was met partially by Government of India Act 1919, and finally, although this state autonomy was provided in 1919 as well, but then that was capped by something called diarchy, where Governor General at the state level had some power reserved. Do you remember something called transferred power and reserved power? reserved power, right? So through this diarchy, whatever state autonomy that was provided through this Government of India Act 1919, that was capped by this diarchy. Finally, you had this Government of India Act in 1935, through which complete state autonomy was provided. But complete state autonomy, if Britishers are providing, of course they will come up with some stick. If you remember, while discussing this Councils Act, we had discussed something called carrot and stick policy, right? So throughout this reform movement, or whatever reform that Britishers were extending to us through these Councils Act, or through any kind of Government of India Act 1919 or 1935, they were continuously following this carrot and stick policy. In form of carrot, if they were providing something called reform, they were continuously applying this stick as well, and through this stick they were also giving us something called checks and balances. So at one hand they are providing these reforms, and another hand, right, they will have some controlling mechanism through which those reforms to some extent could be checked, right? So this governor, creation of this post called governor was nothing. When we started demanding state autonomy, this post of governor became a tool to control that state autonomy. So you had these elected state governments in the state at the provincial level, right? You had this elected government who had all the powers to take matters in the development sector, to take decision in development sector, to take decisions in legal sector, to take decision in all sectors. But in 1919, as I already told you, that there were some power that was put under the reserved category, and those reserved category was under control of Governor General. In 1935, complete state autonomy, but if complete state autonomy is to be given, right, they will have some power, that Governor General will be equipped with some power, right? And that equipped power was this section 93 of Government of India Act 1935, which empowered state governors or Governor General in the provinces to destabilize or to put elected state government in a suspended mode if they go against constitutional lines. And who would decide this constitutional lines? It is ultimately this British government at the center, right? So the role of governor originated through this Government of India Act 1919 and 1935, right? What was the purpose? The purpose was to control the state autonomy that was being provided, state autonomy that was being provided through these two acts, right? So the carrot and stick policy, carrot and stick policy, continuously they were applying, right? So I hope this origin of office of governor, in which circumstance this office of governor emerged in the British time, you would have understood. Let us read this. So with the demand of state autonomy rising through these national movement, Britishers devised mechanism to have an element of control over the state. In 1935, with British retreat from the state, governors' role in the states gained prominence. Bureaucrats were appointed as governor to further British interest in democratically elected state governments. So this section 93 of Government of India Act 1935 is nothing but it is a reflection of Article 356, rather not reflection, Article 356. If you want to see the origin of Article 356, which empowers governor of the today's times to impose, or not impose, but rather recommend to the president to impose president's rule, right? So the origin of Article 356 can be traced from this section 93. So we had wide discussion on this portion when we were discussing emergency chapter. Let us read this again. So through governor, coupled with Section 93 of Government of India Act 1935, governors were empowered to suspend democratically elected governments in state if they did not act in a manner favorable to British. Most notable abuse of this power. So you will see that as soon you had this election in 1937 in the state for the state governments, right? You will see by 1938 you had 3 to 4 democratically states, right? A democratically elected government which were suspended using this power of the governor. So my point is that it is in this circumstances, right, to curtail on the state autonomy. You had been awarded this state autonomy through these state autonomy through these 1919 Act and 1935 Act. So to curtail the state autonomy, you had this governor, and he was equipped, or he or she was equipped with these kind of powers, right? So most notable abuse of this power for 3 or 4 government had already been suspended by 1938, and the most notable abuse of this power came when Fazlul Haq government. You had this Krishak Praja Party. Modern history, you will get to read this Krishak Praja Party. So this party was supported by Hindu Mahasabha as well and Congress as well. Means two contrary party, ideologically contrary party was supporting this party, and this party was led by Fazlul Haq, and he was prime minister in Bengal region. And because this particular government was not functioning as expected or in the manner that Britishers like, so that elected government was suspended. And in place of this, Muslim League government was allowed to form the government, because Muslim League government started functioning and they were showing signs कि भाई आप जो कहोगे हम लोग करेंगे. So in these kind of circumstances, you had this emergence of office of governor. In 1937 itself, Congress started protesting against this post of governor कि governor का जो role है वो आप reduce करो. This kind of sweeping power that you have awarded to the governor, that needs to be taken down, because elected governments cannot be revoked by these unelected bureaucrats. ये unelected bureaucrats ही होते थे जिनको गवर्नर बनाया जाता था, right? So Congress started demanding कि भाई ये जो unelected government, ये जो provision है in the constitution in 1935 act, right? इन provisions और governors को जो sweeping powers आपने दे रखी है, वो sweeping powers, and it is because of these sweeping powers that this governor office had become notorious for destabilizing this state government. Now let us try to understand कि अगर this governor's office had become so notorious, so what was this necessity of having this governor's office or governor in Indian constitutional scheme, right? अगर ये अपने notorious governors जो हैं, if they were being known for their notorious feature of destabilizing elected government, democratically elected government, so why did we have in our constitution, right? हमने अपने कॉन्स्टिट्यूशन में क्यों लिया? सो लेट अस ट्राई टू अंडरस्टैंड दैट वी अडॉप्टेड फॉर अ पार्लियामेंट्री सिस्टम ऑफ गवर्नमेंट. इन पार्लियामेंट्री सिस्टम ऑफ गवर्नमेंट you have these two people. One is called head of government. So at the central level, who will be head of government? PM. And at the state level, who will be head of government? CM. And another post is head of state, right? So who will be head of state at the central level? So it is president, right? And the state level, it would be governor, right? But if you see, prime minister is what and chief minister is what? They are from the ruling party. They are also leader of the party. So they do have certain responsibility toward their party as well. And the party does have some ideology, right? So BJP does have some ideology, Congress does have some ideology. So at times you will find that these people, prime minister and chief minister, will be motivated more by their party interest than by the nation interest. And you will see that the policy, their ideology will have, you will find the reflection of their ideology in the policy or the acts that will be passed by these governments. So when you see the abrogation of Article 370, the construction of Ram temple, this triple talaq, so these kind of things, if you want to see a common thread into these kind of things, you will find a reflection of a particular party in all these kind of acts, right? So my point is that at times you will see the head of government, PM or CM, they will be motivated more by their party interest than by nation or a state interest. So at such times you need some neutral person at the central level and at the state level. So at the central level you had this president, and at state level you have governor. So these are people who are expected to be behave neutrally, and when acts or policy passed by these houses, Rajya Sabha, Lok Sabha or Assembly, so acts which are ideologically motivated, which are not in interest of general public or public at large, which are addressing only their particular constituency. So in that kind of circumstances, there should be some neutral office or some neutral post that could control or that could say no, or at least they could ask कि भाई इस एक्ट को और इस पॉलिसी को आप थोड़ा सा रिकंसीडर करो, because from my point of view, this particular act or this particular policy or particular behavior is not on the constitutional line. So to fulfill these kind of obligation, you had this emergence of neutral offices called president at the central level and governor at the state level, right, to apply break on hastily passed bills which does not stand on constitutional line or constitutional parameter or may not be in larger public interest. So these people should have power, or these offices should have power. Offices like governor should have power कि they could say no. So with these kind of envisioning, you had this emergence of governor, and this is the reason why we had this governor. So besides these reasons, was there any political reason as well behind having this office of governor? So yes, there was some political reasons as well. So if you try to see what was the political situation at the time when constitution was being drafted, so you had various states like Hyderabad, states like Junagadh, states like J&K, which were continuously in touch with other parties, I mean Pakistan as well. They were negotiating equally with India as well, and they were at the same time negotiating with the Pakistan as well. You had this border states like Punjab, right, where another kind of movement, a movement for a separate nation was ongoing, right. They were demanding, a group of Punjabi were demanding this Khalistan as well. So there was separate, and Pakistan was continuously delving into this area as well. वो foment कर रहे थे इस type के movement को कि आप एक separate movement मांगो. So in border area, in northern state, northeastern states as well, they were continuously demand for a separate nationhood, right. So in these kind of situation, it was necessary that central representatives should be in these state, and whenever the elected state government in these portion ultimately, means eventually these be it Hyderabad or Jammu and Kashmir or Junagadh, ultimately they became part of India, but it was necessary when these kind of things, these kind of trouble is being fomented by external party or Fisaporous tendencies are being promoted either by some internal party or external party, and the politically elected government at the state level, if they are not being able to control these kind of movement, it was necessary that in a state a central agent should be there who could inform or who could give this report to the president or a state government, right, who could have central control in time of exigency or in time of emergency, right. So with these kind of intention, you had this governor's post, right. So besides this one reason where in parliamentary system you need something called head of state, right, to control the ideologically motivated acts, right, there was another reason to have this governor at the time of independence because of the Fisaporous tendencies that were being promoted by external and internal parties. So let us read it. Yes, to control Fisaporous tendencies growing in few of the princely and the border state, it was necessary to have some amount of central control. This central control was to be exercised by governor in event of constitutional breakdown of state, right. It is clearly alluding to Article 356. Example, if Khalistan movements revives an elected government for the political reasons, so there are political, so suppose the elected government in Punjab, if they see the short term benefit, right, in supporting these kind of movement, if they see कि भाई 5 साल और 7 साल हमें इस तरह के movement को अगर support करने से अगर मुझे एक particular section का vote bank if I is able to secure, right, so they'll support this without looking at the long term loss that it will cause to the country. So there may be political reason to support these kind of movement, right. And if governor sees कि ऐसा कुछ हो रहा है और elected government is not doing anything, in that case governor should have power, and governor has been empowered through this Article 356, right. So these were some reasons, these one reason and two reasons that I cited, these were 2 or 3 reasons that you can cite behind having the governor's role in what you call Indian constitutional scheme. Despite having experienced these ills of the governor's office or governor's power in the Britishers' time. So despite having seen those ills, we adopted this governor's office in Indian constitutional scheme. So I hope you would have understood the reason. So now we'll discuss this position of chief minister with respect to governor. So if you notice, the heading of this chapter is position of governor or position of chief minister with respect to the governor, while the slide, the images are of president and prime minister. The reason being the same parliamentary system that we do have at the central level and the same parliamentary system that we do have at the state level. So whatever power or whatever function that has been envisioned by the constitution for the president, the similar amount of power has been given to the governor at the state level, or whatever role that has been envisioned for the prime minister at the central level, similar powers has been envisioned or similar function has been envisioned for the chief minister at the state level. So if you remember, to the president at the central level we were calling that he will be head of state, while prime minister will be head of government. He will be de jure head, while he will be de facto head, means real power or real decision making power will be lying with the prime minister, while he will be only symbolic head. He will have just nominal power. He will be called titular head, right? He will be called titular head, and he will be holding only symbolic power. All the executive functions will be taken formally, means formally when I am saying just that whatever decision that will be taken in his name, but those decisions will be in real manner, will be taken by this man, prime minister, right? That's why it is called that he will be holding, prime minister will be holding real power, right? Whatever decision or whatever acts or whatever policy that has to be passed, or in which direction, right, what will be the direction of the government, right, that will be decided by this prime minister, including council of minister, right, and he will simply forward that recommendation that hey, this act has to be passed, or this decision has to be taken, or this agreement has to be signed, or this international agreement has to be signed, right, that will be signed in his name, that president is doing this, president is doing that. That's why it has been called that he'll be titular head, he'll be ceremonial head, or he'll be nominal head. So whatever words that has been used, right, any of the word you can use in reference to the president, right? So as I was saying that whatever power that president has been given at the central level, the same amount of power has been given to the governor at the state level, and same with the prime minister and the chief minister at the central level and state level. So what you have to do is, while discussing the role, you just need to change the image, that's all. So at the governor at the state level, the governor will be called with the same kind of name, or governor will have same function or same roles that has been envisioned for the president at the central level, and same with this chief minister at the state level, right? So position of chief minister with respect to the governor would be clear to you, I hope, right? So the governor is called head of state, titular head, nominal head, symbolic power he'll wield, right, while he'll be real, means along with chief minister, along with council of minister, he will be head of government, he'll be de facto head, and this council of minister, including chief minister, will wield real power. So I hope the position of chief minister with respect to the governor, as far as power of the governor, be it constitutional discretion or be it situational discretion, right, we'll have a discussion on this in the next video, but this position of chief minister with respect to the governor, I hope, would be clear to you. Now we are moving to the next slide, and this is the core of the governor. So this is the second article in part 6 of Indian Constitution. Part 6 of Indian Constitution, the first article was article 152, that was discussing about the general information related to the state, and article 153 that deals with the governor, right? So article 153 says that there shall be a governor for each state. The corresponding article, if you remember when we were discussing the president, so article 52 was the corresponding article which said that there should be a president of India, right? So article 153 is saying that there shall be governor for each state. However, in 7th constitutional amendment in 1956, amendment was done to this article, and now it says that provided that nothing in this article shall prevent the appointment of the same person as governor for the 2 or more state. What is the meaning? The meaning is clear that if center due to any reason, if center does not find any suitable candidate, or for any reason if center is not able to appoint governor of any particular state, 1 state or 2 state, what the center can do is, or president can do is, mind you, the president is the appointing authority for this governor. We'll discuss this. So in those kind of situation, what center or president can do is that suppose you have this Madhya Pradesh, you do have Uttar Pradesh, and you do have this Rajasthan. Now Rajasthan governor's term has expired and Uttar Pradesh governor's term has also expired. So what president in such situation can do is that he can ask MP governor to take additional responsibility of UP as well and Rajasthan as well. So that is what the 7th constitutional amendment has done, that it can ask the same governor of a particular state to set or to share additional responsibility of governor's office of Rajasthan or UP as well, right? So that is the point, that appointment of the same person as governor for 2 or more states, right? So that was done by 7th constitutional amendment. So this is the first article which says that there shall be governor and nothing in this article shall prevent center from appointment of same person as the governor of 2 or more states. I hope this article 153, so the learning here is that this is the article 153 which talks about कि governor होना चाहिए in a state, right? So I hope this point you would have understood. Now we are moving to the next article, that is article 154, and article 154 talks about the executive power of the governor, what executive power that the governor will wield, right? Although on the we'll have a separate video on the discussion of the legislative power, executive power, judicial and financial power that governor does have, right? Mind you, governor does not have any military power that president had, right? Governor also does not have any constitutional powers, right? So we'll discuss there, right? Let us discuss the executive, what has been discussed in article 154. So article 154 reads that executive power of the state shall be, so this article we already mean, this not particular article but similar functions of the president we already have discussed. So whatever meaning that we discussed there at the presidential level, at the center, and that was article 53 that was discussing about the executive power of the president at the central level. So the lines were seen, right? And we had a wide amount of discussion there, that what is the meaning of the executive power of the president that is vested with the all of the union's power. So let us read this. The executive power of the state shall be vested in the governor and shall be exercised. So let us understand. So whatever executive power, whatever agreements, whatever MOUs that will be signed by a particular state government with another state government, or with the union, or with another party, maybe with some contractor. So suppose a road construction is to happen, right? So the state government will sign, so suppose 460 kilometers of a state highways construction has to happen, and this construction award has been given to a particular company or a particular contractor, right? So the state government will sign a contract with that particular contractor. Now that MOU or that contract will be signed in the name of what you call state government, right? And the signatory would be governor, although governor does not directly sign such kind of contract, but whatever contract that will happen, right, that will happen in the name of governor, right? And that is the meaning of that the executive powers of the state shall be vested in the governor and shall be exercised by him. It will be exercised either by him or any officer subordinate that has been appointed by him, right, in accordance to the constitution. And when it is referring to this officer subordinate, this officer subordinate will be none but it will be council of minister headed by chief minister, right? So let us read it again. The executive power of the state shall be vested in the governor and shall be exercisable by him directly or indirectly by any officer subordinate to him in accordance with the constitution. So I hope this article 154 4 that deals with the executive powers of the governor, or says that executive power of the state shall be vested in him, right? That you would have understood. Now we are moving to the next article, and here we are not spending much time deliberately, because all these things, what is the meaning of this executive power shall be vested in the governor, right? So already we had discussion, wide amount of discussion when we were discussing the president. So you can simply take it as a revision measure for the power of the president as well. Now let us discuss about the appointment of the governor. So it is article 155 which deals with the appointment of governor. So if you can see on the screen, what does this article 155 read? So it reads, the governor of the state shall be appointed by president, right? And as soon it says that he shall be appointed by the president, what does it mean? Because president does not do anything at his own, right? So it is the central cabinet which will recommend which person should be appointed as president, a governor at the state, right? And then president will appoint this governor by warrant under his hand and seal. I am not going to explain the meaning of what is the meaning of by warrant under his hand and seal, because we already have explained it umpteen number of times when we were discussing the president and president's power, right? So in the previous slide, if you could see, he is appointed and he is not elected, right? Governor is not elected. So if you see the constituent assembly, there was suggestion that we should have a elected government in each state, but this elected government would have created many kind of conflicts. If you see, if we would have elected governors directly, so that at the state level you have this council of ministers, or you have these MLAs, those are elected directly, and these MLAs goes on to form this government, right? So you already have an elected chief minister at the state who wield some power, some amount of power, and if you are electing your governor directly as well through this universal adult franchise, then you will have to share this CM's power, some function or some power with the governor as well, because ultimately if your CM is elected, he is also elected, right? So he will also fight for some amount of power, and if he is given, this governor as well is given some amount of power, that will lead to some amount of conflict as well. You will see that there will be creation of dual power centers. Governor will start asserting itself, right? Right now he is elected, he is appointed by the president, and that's why you will not see much amount of assertion. But if he is also coming directly by the election method, he will start fighting with the CM that yes, if you have been directly elected by the people, I have also been directly elected by the people, and that will lead to the spat between chief minister and the governor. That may create issues of coordination, that will create delay in the decision making. So it is due to these reasons it will lead to the more politicization as well, right? Because CM would always like कि भाई उसका जो नॉमिनी है वही गवर्नर के लिए इलेक्शन के लिए फाइट करे, और पार्टीशनशिप कांग्रेस चाहेगी कि भाई हम भी गवर्नर के लिए अपने पर्सन को कॉन्टेस्ट करवाएं, बीजेपी चाहेगी कि हम भी अपने पर्सन को गवर्नर के लिए कंटेस्ट करवाएं, राइट? सो दैट विल लीड टू द politicization of this particular office. And the ultimate objective, what was this ultimate objective? The ultimate objective behind having president office at the central level and governor's office at the state level was to have neutrality in this office, because neutrality nahi hogi to he will also take biased decision, right? So the ultimate objective was कि whatever acts or whatever policy that this CM, chief minister, who is a political head of another party as well, so whatever decision, politically motivated decision or whatever politically motivated acts that he does pass from the assembly, उसको कुछ देर के लिए control करना, उसको reconsideration के लिए भेजना, right? So if he also is biased, this governor office is also biased, right? That ultimate goal will not be fulfilled. So it is because of these reasons, राइट, दैट वी फाइनली डिसाइडेड कि नहीं, गवर्नर जो होगा वो अपॉइंटेड होगा. एंड फाइनली वी फॉलोड दिस कैनेडियन मॉडल. इन कैनेडियन मॉडल you have this appointment. They also do have provinces like us. We to the provinces we call states here, right? And states in Canada is called provinces. So in their provinces as well, governor is appointed. So one keyword here is, or one learning is, that the post of governor we have taken not from what you call Britishers, we have not borrowed it from the Britishers, but we have adopted a Canadian model, not from USA. USA में directly जो governor है वो directly elect होता है. So I hope you would have understood the reason why we do not have this elected governor, why we do have appointed governor, although this appointed governor is also going to cause some problems, right? We'll see in the course of this video that what appointment or what problem this appointment will create. Now you do have article 156 that discusses about the term of governor, right? So the term of governor will be 5 years, and that is mentioned in the constitution. But this term of 5 years is not fixed, that is subjected to something, and that something is pleasure of president. So as long as president wants, right, he'll stay in office, although again I am emphasizing that this 5-year word has been mentioned in the constitution as far as term of governor is concerned, but it says that subject to the foregoing provision, मतलब पिछले provision को अकाउंट में लेते हुए. एंड व्हाट इज दिस पिछला प्रोविजन? द प्रीवियस प्रोविजन इज दैट द गवर्नर शैल होल्ड ऑफिस ड्यूरिंग द प्लेजर ऑफ प्रेसिडेंट, राइट? सो प्लेजर ऑफ प्रेसिडेंट का डॉक्ट्रिन जो है वो गवर्नर के रिलेशन में है. सो एज लॉन्ग एज प्रेसिडेंट इज प्लीज्ड विद द परफॉर्मेंस और प्लीज्ड विद एनी रीजन, ऑल्दो मोस्ट ऑफ द टाइम ये जो प्लेजर जो हटता है गवर्नर से, द रीजंस आर मोस्टली पॉलिटिकल, right? So if governor is not performing on the lines that center like or the cabinet likes, right? So cabinet can simply recommend कि भाई आप उस president governor को suggest करो कि वो या तो resign कर दे, otherwise will terminate his services, right? So as soon president removes his pleasure, this governor will have to go, right? Governor may by writing, there is another method as well by which governor can vacate office, and that is by writing his resignation that will be addressed to president, right? I hope this point you would have understood. Provided that governor shall now, notwithstanding the expiration of his term, continue to hold office until his successor enters into the office. So there may be at times where 5 years of the governor has been completed in a particular state, but center has not been able to find any suitable incumbent for that particular office. So it may be for 3 or 6 months or 2 months until you have this incumbent found by the center, right? Until then this same governor can be asked कि आप continue उसी office में आप continue करो, and again that has been mentioned in the constitution. So if you see, term is 5 years but with this asterisk sign, and that asterisk sign is pleasure of president. So as long as president is pleased, you will continue in the office. Maximum period is 5 years, but there is an exception, and that exception is that if center or the cabinet has not been able to find the suitable candidate for that office, you may be asked कि आप continue करो, right? Re-election for any number of times, right? So it does not matter how many times you have been governor, right? So 4 times, 5 times or 6 times, there is no capping on the number of election or number of re-election that a governor can see. So if you notice, there is no formal procedure for the removal that has been mentioned in the constitution for the governor. Equivalent of governor at the central level, you have this president, and for the impeachment of president, you have something called article 61, in which the removal procedure or impeachment procedure for the president has been mentioned, but there is no such grounds that has been mentioned for the removal of the governor. He is completely subjected to the displeasure doctrine of the president. So as long as president is pleased with the performance, and it is not actually the pleasure of the president, it is in real sense, if I do not follow this constitutional line that has been written, in the real sense, because president does not do anything on his own, right? He is always guided by this cabinet's advice, right? So as long as this central cabinet is happy with the performance of this governor, right, this governor will continue in his office. As soon this pleasure by the president has been removed, means pleasure by the cabinet has been removed, right, he will have to go. And this is going to, this is nothing but this is a controlling mechanism, right? By having control on the term, right, you already have written that okay, you are giving this 5 years, but that is subjected to the pleasure, right? So as long as, so suppose 2 years down the line of the appointment, if that governor is not following the dictates, indirect dictates, because in the constitution it has not been mentioned. Let us see one another feature, right? Just because center is appointing or president is appointing, it does not mean that this office, a governor's office, by any means is subordinate to the central government. No, that has been interpreted by Supreme Court that yes, he do have, we'll see the role of the governor. So as part of role, he is called as agent of central government in the state, right? So although he is called agent of the central government in the state, but this office of the governor in no way is subordinate office, or this is not an employment under the central government, right? Because this goes against the constitutional ethos or constitutional spirit. I hope this point you will have understood. So as I was discussing that this mechanism of control over the term, right? So suppose, as I already told, that 2 years down the line, if central government is not happy with the performance, and how does central government measure the effectiveness or the performance of governor? So most of the time the governor's performance, especially in vitiated political environment that we are living in, most of the time you will see that the governor's performance is decided on the political lines. So if he or she is not following the central government's dictate or the ruling party, central ruling party's dictates or ideology, he or she will be suspended. Simply central government will recommend president कि आप अपना pleasure जो है वो remove कीजिए, and you can suggest this governor to resign from his office, and if he does not willingly resign, he can be terminated. So this term control over term and control over appointment, because appointment as well, if you remember from the previous slide, appointment as well happens from the president, and that's why central government does have complete control over this governor's office. And it is in this regard that you will see various committees and commission that has given. So you will discuss in this video itself that what is the Sarkariya's commission recommendation regarding governor, that he should be given fixed term, right? If he is being removed prior to 5 years, there should be compelling reason. That reason should be stated. What kind of person should be, whether that person, because eligibility criteria, when we'll discuss, you will see that the only eligibility criteria that has been mentioned in the constitution, that he needs to be citizen of the India and he should have completed this 35 years of the age, right? So there is no mention in the constitution that whether this person may be political or not. Most of the time you will notice that governor is a political appointee, right? So the person who has remained from the ruling party, this governor office is awarded to that person as a post retirement feature. So suppose from a party a person has attained 80 years, now he is not bringing electoral benefits to political party, he will be given as a award, this governor's office, right? So we'll see what are the recommendation of various committees and commission, we'll see that, right? So all these points we already have discussed in this term section. This point we already have discussed. What is the qualification? So as I already told you that this is article 157 that discusses with, or that deals with the qualification. So there are only 2 qualifications that has been mentioned in the constitution. The first qualification is that he needs to be citizen of India and he should have attained this, or he should have passed this 35 years of the age. As far as these qualifications are concerned, this qualification has not been mentioned in the constitution, but that has developed over a period of time as a political convention, right? So if there is a question that is being framed in the prelim and they ask that what are the constitutional qualification for the office of governor, you will have to tick mark only these 2 points, right? So what is the political convention that has developed over a period of time? So political convention is that he should not belong to that particular state where he or she is being appointed. So that is the political convention. And the second is that the president who is appointing authority for the office of governor, he or she should consult chief minister of that particular state where he or she is scheduled to be appointed. So most of the time, at least this convention is being followed, right? But this convention that the president should consult chief minister before appointment, this convention has been followed only for 10 or 15 years, and especially under very democratic central government. But this generally president just inform and not inform as well, right? These governors are imposed on these states. right? Central government simply appoint, president simply appoint, and he is sent, just a notification is given that this particular governor is being sent for this particular state, that's all. So this political convention as well is not being followed very sincerely. Again, I am pointing out that as far as qualification is concerned, right, the only two qualification has been mentioned in the constitution. These are convention, political convention that has developed in our political system over a period of 70 or 72 years, right? Now let us discuss what are the conditions for the office. So if you or any person or like me or you if want to be governor, right, what condition he or she should meet? So the first condition of course is that we should not be holding office of profit. What is this office of profit? We have dealt it in very detail, right? We had this 32 minutes video. If you are not clear about what is this office of profit, you can refer to that video as well. So first condition is that the person who wants to be governor or who wants to get into governor's office, he or she should not be holding office of governor. Then he should not be member of parliament or member of legislative assembly. In case if any member of parliament or member of legislative assembly member becomes governor, then he should vacate this post of member of parliament or member of legislative assembly on the day that he enters this governor's office, right? He should not be member of parliament or member of legislative assembly. If member of parliament or member of legislative assembly is appointed to the governor's office, he or she should have vacated this office before assuming governor's office, right? So these are the two conditions that again has been mentioned in the constitution. Mind you, the previous one were the qualification. These are the conditions, right? So the separation is necessary. Governor's emoluments, right? So this is a common feature across all the constitutional functionaries, that governors what you call emoluments and allowances and privileges are to be determined not by the president, mind you. So this can be a trap in any of the prelim statement, because he is appointed by the president. So the normal temptation may be in the while attempting prelim question that yes, emolument, privileges and allowances would be of course decided by the president itself, because he is appointing authority. But mind you, his emoluments and allowances will be determined by the parliament and not by the appointing authority. Another provision that his emolument and allowances cannot be reduced during his terms, and his allowances are charged on consolidated fund of not India but consolidated fund of states, right? I hope this point you would have understood. If same person is appointed governor of another state as well, so as I discussed in the previous case, suppose you have Rajasthan, you have UP. Now Rajasthan governor's term has expired, so UP governor can be asked कि आप इसका भी charge जो है additional function you can take, but in that case the salary of this governor of UP will be shared by Rajasthan as well. Now what will be the manner, what percentage of salary will be given by consolidated fund of Rajasthan and what amount will be given by the consolidated fund of UP, that will be determined by the what you call president. That formula will be decided by president. Here this strike through should not have been there, right? So it will be determined by, that formula will be determined by president. So again a separation here. Emoluments and allowances, salary and allowances were being decided by the parliament, but in case of sharing, किस तरह से शेयरिंग होगा, that will be determined by the president. इस strike through को आप भूल जाना, right? That is a mistake. So that will be decided by the president, right? So I hope condition of the office under article 153 would be clear. And one thing, these articles you need not to remember. Again I am pointing out, you need not to get boggled down कि यार ये articles कैसे याद होंगे. You need not to remember. Whatever very important articles regarding a particular chapter would be, I'll have a separate slide at the end of that chapter. I'll point out कि हाँ भाई ये जो है articles for this particular chapter is necessary to remember, and those articles you can remember. So I hope that point would be clear. Now what about the oath of governor? So oath of the governor is administered by High Court Chief Justice of that particular state, right? And this is a bidirectional oath administration. What is this bidirectional oath administration? So governor will administer oath to the High Court Chief Justice, and this High Court Chief Justice will administer oath to the governor. Mind you, one separation, that High Court Chief Justice is not appointed by the governor, right? His oath only, means High Court Chief Justice oath only will be administered by governor. He is appointed, this High Court Chief Justice is appointed by president. So you need to separate between appointment and oath administration, and that's why this language, that the bidirectional oath administration. Governor will administer oath of the High Court Chief Justice, and High Court Chief Justice will administer oath of the governor. Oath is mentioned, oath of the governor is mentioned in the third schedule. No sir, no. His oath is mentioned directly in the Constitution in Article 159. The same point I had raised when I was discussing the oath of the president. So oath of the president and the governor is mentioned in the Constitution directly in the articles and not in the third schedule. The third schedule that deals with the oath of the important constitutional functionaries, you will see that union minister, state minister, CAG, judges of the Supreme Court, judges of the High Court, their oath has been mentioned, but as far as governor, you will not see governor and the president here, right? So here you can refer that the third schedule does not deal with the oath of the governor, that has been mentioned directly into the Article 159. If you want to see what will be the content of oath of the governor, so this is the content of oath of the governor. So these three important line oath that the governor's oath will have. So to preserve, protect and defend the Constitution and the law. So this was the same oath that the president had taken. This line was present in the president's oath as well. Faithfully execute the office of the governor. So this is again a common line that any constitutional functionary, if he or she is assuming any important office, so you have union minister, you have the state minister. So as soon they assume any office, any important office, so they do take office. Whatever office that is being awarded to me, I'll faithfully execute the duties of that office. So here the governor is taking the oath that governor's office I am entering into, so I'll faithfully execute the duties that a governor should have, right? Devote myself to the service as well as well-being of the people. So I hope this content of oath would be clear, that has been dealt in Article 159. Let us discuss the privileges and immunities of the governor. So privileges and immunities of the governor are same that is enjoyed by the president. So you can take it as a revision measure for the president's privileges and immunity. So as far as immunity or privileges that governor has been given in criminal matters, so in criminal matters he has been given a blanket immunity. So does not matter whether he performs any criminal activity in personal sphere or in line with his duties, right? He has been given complete immunity, complete blanket immunity, enjoys complete immunity for criminal acts both in official and personal capacity. But mind you, as far as civil acts are concerned, civil matters are concerned, this blanket immunity has not been given to the governor, right? So if in personal sphere, if he is doing any crime that falls under these civil aspects, right, then he can be charged. So suppose if any contract he has violated, so a person like me or you can violate governor of any state or even president of India, right, if he has violated any kind of contractual obligation, or if suppose there is a land case that is in between me or the governor or me and the president, so I can sue the president, I can, or you can sue the president, or you can sue the governor. The only condition is that you or I will have to give him or her 2 months of the prior notice. That in president office or in governor's office, you will have to send this 2 months prior notice that I am going to sue this particular governor or president because of so and so reason. So for the official acts, right, this immunity has been provided in the civil matters as well, but as far as his personal acts are concerned in the civil sphere, he can be charged. after giving 2 months of notice. I hope you would have understood the privileges and immunities as well, right? What is the problem with the current system of appointment and its repercussions and related recommendations, right? We'll discuss, these are the political aspects, so we'll discuss what is the problems with the current system of appointment and repercussion in the next video. I am wrapping up in the Sarkaria Commission recommendation. In the next video, I am wrapping up this video here itself. So here are 4 or 5 MCQ that I have put up for you to attempt. So this is the first MCQ, second MCQ, third MCQ, fourth MCQ, and the fifth MCQ. So these are the 5 MCQs that you are supposed to attempt. Until I come up with the next video, bye bye.